who keep look at this man's name, who keep putting my videos up, and I don't see a name on here. I was gonna call his name specifically. Oh, I think his channel is called, oh, I don't want to tell y'all because y'all might go to it. Okay. Anyway, I want him to stop putting these videos up, and I was trying to comment on his page, but I might have to subscribe. This is case number 235530201, the people of the state of Michigan versus Diana Christian. Somebody tell time served I said stop putting my videos up.
Welcome, people. How we doing? What can I say? Either one of two things. One, can't stand me. Take a number. Or two, Mrs. Time Served brought it to my attention. Not only did she tell everyone my name, which she said she wasn't, then she said she was going to subscribe. 3, he said, I watch his videos. Essentially, 3. So, what should we do about this? I don't know. And not for nothing, the comments, I'm just done with them. Because the same people who watch not only my videos, but everybody else's videos are the same ones that are telling me to get a life, that are telling me, what was the other one? Just stupid, like no point for it whatsoever. Newsflash. Hundreds of channels before me. There's been hundreds of channels after me. Don't know why. I am always the bad guy. Other creators, check. Now judges, check. I don't get it. But the best part about it all, I have never, ever said a negative thing about her my entire time on this channel. Matter of fact, I'm one of the only creators that put her golden moments. I like the videos of her being compassionate, caring, loving, outstanding. I put the short I found of her praying because I feel that how awesome that is. So there's a thing called fair use. I don't just rip and upload, and it's for entertainment purposes, and it's on YouTube. I apologize. If you want to come on and have a discussion with me, and you bring up valid points, let's go, and I'll never put you on again, because I'm not a dick. But I guess no publicity is bad, and good attention is good, bad attention is better. So, it was great. I loved it. And I still love watching her because she's fantastic. So, without further ado, let's get into the clips. We have about 75, 76 of you in there. Just had to get off my soapbox. I'm going to hear it in the comments. Don't care anymore. If you don't like me, don't watch me. Okay, so here we go, because I am loyal to the ones that have been here since day one and the ones that are coming in and show me love. If you hate me, watch my stuff, comment, don't care, because I'm not reading the comments anymore. So here we go. Let's have some fun. Let's go to... oh, let's do it. So I know there was a really good Simpson video, but I'm just so tired of it. So let's go to this one. Ready? Here we go. Oh wait, hold on. I'm not even queued up. I'm all scatterbrained from that today. Here we go. Let's do it. Give me 1 second. It's almost like the Roman Colosseum. They cheer to see the gladiator. They hate the gladiator, but they always watch the gladiator. Saying. Okay, here we go. Oh, let's do it.
Good morning, if it may please the court.
Yes, yes, sir.
Okay, sorry guys. Cue it up. Have some fun now. Back to the show.
What type of case do you have today? I don't see on the docket.
It's a traffic case. I guess they say I was smoking marijuana or something like case like that.
Okay, so that's to be with Judge Larry Williams in courtroom 332. This is docket in January.
What were you smoking?
Okay. All right. Thank you.
Marijuana?
She's all right.
I think so. I'll just log out, then I look for the name, right?
Trying to figure out how to.
And what you need to do also is take your hat off when you show up for court in his courtroom.
332, right, ma'am?
Yes, that is correct.
Okay. All right.
That was great. Absolutely wonderful. All right, next one. So Judge Perkins, he's always got some intriguing cases. This one was really good. They caught a guy just outright lying about whether he was pushing or driving his moped. It is phenomenal. Here we go.
Counts two. Appearance for the record, please.
Good morning, if it may please the court. Sarah Robinson, court appointed attorney for Mr. Dior Gregory. I've not had contact with my client. The phone number that I was provided is not in working order. I did send out an introductory letter and have not heard from him yet.
Let's see, it's 2 counts. One of the disorderly conduct and interfering with government employee. I have a number here, and it's a 323 area code. See if this matches to what you have. 323 723 1649.
I'm checking, Judge. That's the number I called. 723-323-723-1658 is what I called.
48.
All right.
Why don't
Well,
you try?
let me call that number.
All right, let's pass that matter. Ms. Snyder, I just saw her in
I'll
the
call you back.
I'm back,
All
Judge.
right.
Chris.
I'm here, Judge.
Let's go back on the record with Mr. Goldston. Miss Snyder, can you put your appearance on the record, please?
Good morning, Your Honor. Alexa Schneider for the people, P80322.
Yeah, okay. Now, Ms. Soroki had indulged you about maybe further going a little lower on Mr. Golston's charge, right? And I know that.
Oh, thank
well,
you,
I know
Laura.
that Officer Robinson was here, and Officer Robinson was against that. But I look at Mr. Golston's record, and outside of
Hey, monkey.
a 2018 failure to display and a 2017 failure to display, he hasn't had any contact with or any abstractions, I should say, with any police officer since 2004. And he obviously, from 2000 and 2004, we don't even have to discuss. He knows what brings him here. And by the way, his thing is only basically 2 pages long. It's 2/3 on one page and 1/3 on the last page, and then 1 page. So let's say 2 pages long of abstractions. And he went to, according to him, he's been to try to get to the review. He did all of the steps. He indicated that he got alcohol related. I don't know if you're familiar with the steps, but you have to get a psychologist. You have to get substance abuse evaluation, 12-point things. You have to have sobriety. You have to have letters. He did that. He was denied. That was some years ago, and he hasn't gotten back. And I don't see why the people, and especially in this situation, for this person, they've been a lot more lenient on people with a lot of worse driving records. He indicated to, go ahead.
Alexa Schneider for the people, P80322. Thank you, Your Honor, for the recitation of the facts. This matter was previously set for trial with Attorney Harris. The officer and myself and Attorney Harris were all present. We discussed this matter at length. Mr. Golston made several statements to his attorney, which were then stated to me, that included lies, blatant lies about what he was doing at that date, blatant lies about what Officer Robinson said. When he was confronted with video evidence clearly showing that his version of events was untrue, he continued to make up stories. He pretended he couldn't watch the video. I'm disinclined to accept.
So to catch you guys up here, what's basically going on is the guy has been in and out of this courtroom, and they have him on video on his moped. I'm not going to give it all away, but at this point, Judge Perkins is actually on his side and saying, listen, he's doing all that he needs to do because he was driving a moped drunk. You can't drive it drunk. It's a moving vehicle. So what she's saying is that they have him on video, and he's lying and say, I can't view the video. I can't do this. I can't do that. So Judge Perkins makes him come into the courtroom. So you'll hear him lie after lie. It just builds. It gets great. So I just want to catch you guys up, just getting into the chat. Welcome, everybody. Yeah, it's a moped. We'll hear it. It's the best.
His recitation on anything about what he's learned about driving, about his record. I agree with Your Honor. It doesn't.
Thank you, Doodle
necessarily
Mom.
gone
I
this
have.
far. We made a fair
I have.
offer at the beginning. It's Mr. Golston brings himself to this position, not me.
All right. I know that you did have opportunity, and Ms. Harris, and you went back and forth. And I did understand that there was a video.
Yeah, volume is low in Perkins. I have it turned all the way up. He's just never by the mic. I'll try to get it as much as I can, guys.
obviously I've never seen the video. He indicated today that he was riding in a bike lane at first until that bike lane ran out.
Here we go.
And that he indicated some side streets where he was riding in.
He pretended he couldn't watch the
Here
video.
We go, guys.
I'm
Sorry.
disinclined to accept his recitation on anything about what he's learned about driving, about his record. I agree with Your Honor. It shouldn't necessarily gone this far. We made a fair offer at the beginning. It's Mr. Golston brings himself to this position, not me.
All right. I know that you did have opportunity, and Ms. Harris, and you went back and forth. And I did understand that there was a video. Obviously, I've never seen the video. He indicated today that he was riding in a bike lane at first until that bike lane ran out. And that he indicated some side streets where he was riding, and then instead of riding in the street, he got on the sidewalk. But I don't know what the conversation was between you and Ms. Harris and himself. So I guess that's what sort of brings us to this revoked situation. Ms.
I'm wondering if there's any opportunity for him to take a
Thank you,
class
Daniel.
or anything else
I
like
know.
that and come back for an initial pretrial for reconsideration.
Thanks,
That
Lisa.
would be Ms. Snyder. She's
He did a class. I would take it out of revoked. At least he could do a no ops, maybe an FTD.
We would be greatly appreciative of that, Ms. Snyder. Exactly what.
well.
we
I
want.
just say this though. I mean, I do, and I'm not gonna add any more. But again, that's not gonna get him where he.
And just gonna stop for a second before I forget. Colin, not Cromwell. Good channel. He's just starting out. He alerted me, and the Judge Boyd, if you want to go look, the Judge Boyd chat was turned into the time served, oh my God, Judge Brian show for about a half hour, and Colin kicked it off. That's how I got word. Thanks a lot. Go check out his channel. I'm going to be playing some stuff from him. He's a real good dude. Colin, not Cromwell. One of the mods want to put up his link.
Needs to be, but I will give him an opportunity to take the class.
Definitely not Cromwell. Sorry.
You know, that's why you know, at some point, Mr. Golston, I don't know what the conversation was, but apparently it didn't go very well. And what Ms. Snyder says, blatant lies. And, you know, sometimes you have to know when to fold them and know when to fold them.
Yes.
My phone went dead. Come on. Oh, you gotta get Miss Thomas. Where's Miss Thomas? All right, let's pass it. You have to wait outside till this officer comes in. His phone went dead. So we'll pass it until we get Officer Thomas back in here.
So he shows up. Don't know if it's on his moped or not. He shows up to court. His phone's dead. And so Perkins is like, gotta wait for the cops to come. Get out. As he's telling how many blatant lies he spewed.
All right.
It's not him.
APA Cole she sent me a message.
Thank you, Erica.
She will be here.
Yes, sir. And so we're waiting for this guy. How pathetic. Poor Perkins. Look, tick, tick. I had a jump.
My understanding, their discovery has been found. When was that turned over?
She should have it now. Attorney Robinson
I
should have
don't.
it.
I don't have anything.
Did you check your email?
I
Check
did.
and see if you got something from Troy Miller. He said he was going to send it to you this morning.
Thank you,
Yep,
Tom.
I'm familiar with that young man, and I don't have anything from him.
Because I just got through watching it. I just got through watching it, and it does have an interview with Mr. Little. So she needs to see that. He told me he was going to send that to you this morning.
I don't have it.
Judge with Mr. Golston Elvis. His phone is dying.
All right, I'm gonna dismiss the case.
He's in the hallway.
Okay.
Yes.
I'm gonna dismiss the case.
So at this point, he held another case while this guy's phone was charging. What the hell goes on? Some of these people, they give them all the courtesy in the world, but then other people, it's like, done, throw the book at them. Like this guy, unbelievable. and now the court clerk's like, hurry up, his phone's dying. It's like, we have to hurry around this guy. I can't. So the guy's like, I'm dismissing the case. So judge dismissed the case. He saw in between this guy's phone charging, so we could get back to Mr. Goldstein and the case of the walking, not riding moped.
It's gonna be dismissed without prejudice. So, I mean, this is
Yes. bring-
what was agreed on last week. They're still not there. And I'm not pointing any fingers to who's ever at fault. It's gone on too long. So, Mr. Little, the case is gonna be dismissed, and it's gonna be dismissed without prejudice. You can explain, you can give an explanation if you need to from your counsel, and that'll be it. If it's nothing further, go ahead.
SX ticket as well, I understand.
What's the offer gonna be on that SX ticket with Mr. Golston? Mr. Golston, can you stand up here and, no, put him at the podium, at the, right, no, here, right at the microphone is standing right there. Stand him at the, right there.
Mass chaos.
Yeah, that, right there is good. Okay. All right, let's go back on the record with Mr. Elvis Craig Golston. Mr. Golston, you know, like we were discussing, I kind of sympathize with you because you're out here, you're working, you're still working. I can see you got your uniform on today. I wanted you to come down and I wanted you to see, I wanted you to understand, and you got an opportunity to get, you had two very good lawyers that have represented you. From my understanding, it's been a case where you, according to Corporation Counsel Snyder, you came in here and lied. Blatant lies, she says. You know, I try to tell everybody to listen to counsel before you say anything. And I do that so you don't implicate yourself and tell on yourself and say you were doing it before you've had the opportunity to talk to counsel and before you understood, see, they've given you understanding. But I certainly wouldn't come in here and lie. You want, I mean, he could speak.
Oh, well, the moped was not operating correctly. I explained that.
Say that, speak up, speak up.
I explained to the officer the moped wasn't operating correctly. It's cutting off. I'm just trying to get it from one location to the other. It was actually rewarded for a job done for a senior citizen in the ride.
I can't, turn around. Stand over to, closer to the cabinet, stand next to the cabinet.
Yes.
And turn and face me, please.
Yes, sir. I was operating off and on. I was pushing it and operating at the same time. The moped wouldn't start occasionally, but I was trying to get to home with the moped from a reward of.
So he gets pulled over and says he was operating it and walking it at the same time.
A job done at the senior citizen home. So off
Well,
and
now
on,
I'm hearing something different. You and
coming from work, and I was bringing a moped home trying to get home, but when he stopped me.
did they take the moped?
Yeah, the moped is still with them today from last year.
And from my understanding, the moped was riding fine because you were blazing up that sidewalk.
Well, the moped is put and cut off, put in some wire and stuff. Little details work that need to be done for it to really get it moving. It wouldn't constantly do over 20 miles or 15 miles anyway.
All right. Apparently, Ms. Snyder, even though you lied to her, she still.
I walked in the road, I did, Your Honor. That's why I got to admit, you got a video of the movement, but I was walking it too along, but there was no bike lanes in the area. And it just so happened to get across the bridge and I was on the bridge, but I was actually walking and running. I was, I have to admit to that.
Well, even though you, I think she's still sympathizing with you a little bit, even though you lied to her. And I don't know why people come in here and lie. That doesn't help anyone. She's still allowing you an opportunity to take the better driver's course. Indicated that she may, if you take the course, she may be willing to come off of the revoke to a failure to display. I indicated to her that I don't know how much good that's going to do you, because it's still going to be an abstraction. And that's the first thing that they're going to ask you when you go back to that hearing.
My appearance here will affect that. My appearance here.
No, your appearance here, had you not lied, she could have made it that your appearance wouldn't have affected that.
What part of the lie did I make?
I don't know. I don't know. You had that.
Ms. Harris knew I was walking it and writing it.
I don't know what she was referencing.
Yes, sir. Yes, sir.
I don't know what she was referencing, but Ms. Snyder,
Yes, Your Honor.
you indicated that, does that sound like anything that he told you about last time?
My conversations, it was through his attorney, so I don't want to get too much involved in what he
Right.
said. But the story I was told was that even now he's saying he's pushing. I can show the video. You see him zipping along. I mean, he's riding through it.
He's saying that he had pushed some of it, it started, it was cutting off, it was started, and he's moving, and that's how it was going back and forth. It wasn't running 100% properly.
The video isn't, I mean, it's not hours of video. There's a couple minutes. You see him riding along. It's possible it stopped before or after. He's certainly not pushing it and walking it along like a bike, which is a story he told. And a story I think he's even trying to tell now. He's saying, oh, I'm walking it and riding it. He might have walked it for a second. He's riding a moped. It's not walking a broken bike.
All right. Do you want to take the course, sir?
I'll take whatever you offer, sir, Your Honor.
All right. I'm gonna give him the course. I'm gonna give you, write it down here. I'm gonna put it on a that's gonna be one line on the email address. I'm gonna give you 30 days. You can appear on Zoom on 8/7/2023 at 8:30.
Oh, we will be there.
I would suggest you take this course very seriously. I would suggest you be ready to go back to school on this and be ready to answer questions that myself or Ms. Snyder may have for you to see what you really learned out of this course. I don't, she indicated that she was willing to go possibly to a failure to display. I don't know if you might catch her on a better day or not. I don't know, but I would take the course seriously. Give me the information ahead of.
Hot mic.
There's something popped up. Something popped up. It popped out. It popped out.
Something fucked up.
Something about 12:30.
Oops.
Oh, hold on. You can't because I changed it for Mr. Smith. All right, now you can.
How'd that get there?
ريم أبو شاويش.
Oops. I'm gone.
Thank you. Today is the date set.
Good morning, Your Honor.
Ma'am, hold on. Okay. Good morning. Today is the date set for a pretrial conference. Ma'am, how are you proceeding? You are proceeding without a lawyer, I understand.
Your Honor, I requested this because I was hoping that she's not gonna come in.
Listen
So-
to me. Listen to me.
Yes,
I understand that you are going to proceed without counsel. Is that correct?
no, Your Honor, if she show up, I will need a
Ma'am,
public.
ma'am, do you understand my question?
Yes, I do.
Okay. It is a yes or no question.
No,
My question is, are you proceeding today on your own behalf without a lawyer? That's a yes or no question.
yeah, I mean, yes, can I explain?
No, you cannot. Are you proceeding today with a lawyer or without a lawyer?
Today without a lawyer, but I was hoping that you can
Okay,
get,
so how are you proceeding?
I would like to dismiss the case because she does not appear. And this is the second time.
Your Honor, so there was a pretrial conference held on May 4th, and the complaining witness, Ms. Candace Venable, did appear. I believe the defendant did not appear on that day, but I did have an opportunity to speak to Ms. Venable, and she did indicate to the people that she did not wish to prosecute this matter. So at this time, Your Honor,
You have to stop rocking back and forth. You have,
I'm sorry.
Ms. Ritter, you said, the witness said what?
Your Honor, the witness indicated to the people that she did not wish to move forward with the prosecution of this matter. So at this time, we will not be able to proceed based on a complaining witness's refusal to prosecute.
Today is the date set for a pretrial conference. The people have indicated that they are unable to proceed as the complaining witness does not wish to prosecute the matter. The court is going to therefore, whoops. Dismiss the matter without prejudice as the witness does not wish to prosecute the case. Is there anything else for the record?
No, thank you so
Thank
much,
you.
Your Honor. Thank you so much. I'm very fan of you. I watch you all your YouTube
Okay, ma'am,
videos.
that's irrelevant. No, I said,
sorry.
is there anything else for the record? Is there
No,
anything
thank you.
else for the record? Okay.
No, thank you so much. I just have one
You're all
question, Your
set.
Honor.
You have a great day and you stay safe, okay?
Just one question, Your Honor.
Oh, yes,
Is it-
ma'am.
Is it gonna go out of my record like soon?
I don't know what you mean by that. The case is dismissed.
So
case
it's not on my record.
The case is dismissed. If you represent yourself, you have to figure out what that means.
Oh, okay. Well, I appreciate you. Thank you so much, Your Honor.
You're so welcome. Have a great day and stay safe.
Thank you.
Interested in no fans.
That's what she said. I ain't interested in no fans. I know. I know from experience. Okay, now, if you're noticing, I'm having my little pineapple smoothie because baby Time is trying to grease me up to get Drake tickets. Now, she's 13, and that means I have to go to a Drake concert. Now, is that happening? No. Does she think it's happening? No. Has she given up? No. Will she? No. She actually made a PowerPoint and streamed it while I was watching TV. And then came downstairs dressed as Drake. A for effort, F for venue. Average that out. See you later. We're not going. Okay, next. Okay, this, speaking of parents, this one is an obsessed parent for a good reason. This one's going to split the chat. Here we go. Let's do it. This is a good one out of the 455.
Child, and that the allegation of sexual assault needed to be ruled out. And then CPS contacted mom and informed mom that the ruling would be that the allegation was ruled out and that they would be.
No, it's not her birthday. It's nothing. She said, don't get me braces. Get me Drake tickets. I can live with crooked teeth. I was like, really? Really? I could deal with the overbite. I need to go to Drake. No. Okay. Next.
Issuing a report to that effect. Regardless of the fact that CPS had informed mom that there was no credible allegation of sexual assault, mom withheld the daughter for Father's Day
warning.
weekend possession, which is extended from that Friday afternoon through to the actual Monday afternoon, because the Monday was Juneteenth, a federal holiday. Since that time, Mr. Jusen has been entitled to possession beginning on Friday, June 30th, and he is currently in stanter entitled to possession throughout the month of July, based on the parties' agreed final decree of divorce, which was entered by the court in October 2022. We've reached out to mom to let her know that we would prefer not to pursue a writ of attachment, that we would prefer that she voluntarily turn the child over to dad for his possession time. She has not been receptive to such an offer. So unfortunately, we have come before the court to ask that a writ of attachment be issued. We're also requesting that the court issued the order, but that we still be given time to speak with mom to see if we cannot come to an agreement within the next 24 hours prior to actually moving forward with executing that writ. So we're still hopeful that, given that mom is here, that we'll be able to work out the issue and prevent the need for law enforcement to be involved. But in the event that mom is still unwilling to cooperate, we are asking that the court issue that writ so that my client can have, the next 3+ weeks of his extended summer possession.
All right. Thank you very much, Ms. Preston. I do see that the child's mother is here. If you would please provide your response to what Ms. Preston has just said.
I'm sorry, did you request my response?
I did.
Yes. First
Trigger
of all,
warning.
I wanted to mention that I have not been able to retain an attorney yet, which was part of the reason why I wanted to put this on a hold. However, what I can say is this is not my first experience with CPS. This is not my child's first experience with CPS. I was wary of calling CPS. I was told that I was required to call the CPS because it was important for my child's safety. I have been, unfortunately, Your Honor, my child has been. I have had a lot of difficulty trying to keep my child safe in my ex's environment. There has been assault cases happening in his environment that my child was present, but because of financial issues, I was not able to retain a lawyer. I did call the police and report. There have been many instances of Mr. Josan not releasing my child to me because he didn't want to. And I called the police because I could not hire an attorney because of financial reasons. My ex had agreed in his MSA to keep my child directly not to have my child under supervision, without supervision with his child in regards to inappropriate touching. He agreed and signed that MSA. He sent my child for a week with that son without a supervising adult out of state. I have tried to respect the law, Your Honor, many times with the CPS that I did not call. My child's therapist called CPS because they said that it's important. And every time I followed the law to the T, I was not able to protect my child. But and even though I told the CPS this time, I said, my child knows what this is. She gets punished. If she tells you anything, she will not tell you what she told me. But they said that they are required to do it, and she did not have an outcry. But the representative told me that she got really uncomfortable when they asked her specifically about the specific inappropriate touching. And I could not, as a mother, Your Honor, I could not willingly allow my child to go, even after all these CPS cases that have ended in nothing. I could not let my child go to her dad's, knowing that there is a threat, knowing that my child was not going to say anything because she is afraid of what her dad is going to say. He has said, Mr. Josan, that me being ugly towards him, me countering him in regards to the 5 years of child support that he hasn't paid, in regards to any request for him following the decree or his MSA, that it will affect our daughter. He has said that in writing.
Okay, let me ask you this question, because we can't
Yes.
reopen. The reason why you're here without a lawyer is because if you weren't here, law enforcement was going to show up at your door. Okay.
I understand.
You need to, that's why I have you here. Let me ask you about CPS. I hear there's lots of disputes about child support and 5 years under the bridge. I can't talk to you about that. I do have a question about CPS.
Yes,
now,
ma'am.
I understand that you're saying that you're obviously very traumatic for your daughter. Anyone would have compassion for that. Anyone would. But do you agree with Ms. Preston that CPS, for the instance that we're talking about, did not find an outcry?
Your Honor, my child
Did
chose.
they or not?
The CPS representative told me that the child did not tell them.
Okay, then we need to move forward with this. Here's the situation, and I want you to be aware. They have, what Ms. Preston has suggested is that I unless you can show that your husband's not entitled to possession of the child, there's a previous court order that says that he gets to see her in July. Okay, and we have to comply with that court order. And I hear you, and I have a lot of compassion for you that you don't want to do that. Nonetheless, we have a court order. We have to comply with it. I know there was some CPS action. It doesn't seem like that went anywhere. So now we're at the situation where your husband does get to see the daughter that you have with him, his daughter too, in July. So what Ms. Preston has suggested, she wants me to sign that writ of attachment now and to basically give 24 hours for you to comply with it, or the writ's going to issue. I would rather not sign the writ of attachment just yet. I would rather you just agree that you're going to get your daughter over to your husband's house. Can you do that, or is that not going to happen?
Your Honor, I don't have a legal representation.
It doesn't matter at this point. You're here, and I'm listening to you. There's no, I mean, the only other option was not having you here, right? And so it's better that you're here. That's why we're listening to you. So I'm asking you some options right now.
Your Honor, my child's safety is I can't. Your Honor, I understand that I will be legally responsible, but if I have to choose between my child's safety and being legally punished, I would choose myself.
Okay.
I cannot put my child.
I hear you. I hear you. The situation, though, it's not that it's you that's going to get punished. It's that your child, the deputy's going to come up and pick up your child and take them to under a previous court order, take the child to father for the month of July. That's kind of where we are right now. Now, if I were an 11-year-old child, I might not really want the deputies at my house. If that's where we are with this, I don't see any other options.
Sorry, are you saying that I am forced either whether I wanted or not to release my child to Mr. Josan, regardless of whatever dangers or risks that are facing or could be facing her in that environment, and that the law will not help my
But
child.
I was asking you about, that's why I asked you about the CPS. And it sounds like that wasn't founded. Okay, that's why we started with that. Ms. Preston, can you please put up the court order that we're talking about here so that we all are on the same page about that?
Yes, ma'am. Okay, Your Honor, can you see the parties' final?
I can see that. I want to make sure that that Mother can see that as well. Can you see that, ma'am?
Yes, ma'am. Yes,
All
Your
right,
Honor.
let's go down. Let's go down and talk and see, Ms. Preston, what exactly we're talking about here.
Yes, ma'am. So if we go down to, sorry if I'm giving anyone a headache, and I'll bypass the father state possession and just talk about what he's entitled to right now. We're looking at page 9 of the order, provision number 6, extended summer possession.
Okay.
We're looking at without written notice by April 1st, because my client did not provide any written notice for extended summer possession.
Okay.
And it says if he did not provide written notice of a specific extended period, he is entitled to possession of the child for 30 consecutive days, beginning at 6 p.m. on July 1st and ending at 6 p.m. on July 31st.
Okay, now let's go to, now did a judge sign off on that order?
Yes, ma'am. The order was rendered in 2018. And then I believe Judge R signed it.
Well, let's take a look at Judge's signature. Okay, so it looks like that this divorce was judicially pronounced and rendered on June 22nd, 2018, and further noted on the court's docket sheet on that same day, but signed on August 5th, 2022. Okay, so this is a court order. Is that what you're saying, Ms. Preston? A court order for a father to have this child, possession of this child in this July. Is that right?
That is correct.
Okay, so that's the issue that, Mom, and I wanted you to see that, because the thing is this has a power of a court order. And if you're saying, I don't want to comply with this court order, I don't want child to go there, then father will be in the position of being able to have this writ of attachment issue, and the sheriff deputy come to your house and pick the child up and take the child to father. And that's hard, going to be hard on a child. So what I'm asking is, wouldn't it just be a whole lot easier on your child to comply with this court order? Because I don't see any way around it.
Your Honor, I hear what you're telling me. My understanding is that you're telling me that basically there's nothing I can do. One way or the other, I will be forced to hand over my child to my ex.
Under this order.
Yes, under this order. So
Court
it will
order.
either be
Yeah.
either be I hand her over myself, or that the authorities come and take her. So there is no third option. Is that correct?
At this point, I'm not seeing a third option now.
Okay.
Yeah, so I mean, and this is why I'm saying we wanted to get you on this call.
I understand.
I understand you're saying you don't have an attorney. You should try to go get you an attorney. I understand you've got to take care of a sick family member. I totally understand. This, though, takes precedence because your husband has gone and hired an attorney who's going to issue a writ of attachment under this previous court order, which means law enforcement is coming to, if I sign it, which right now I'm not seeing any reason why I shouldn't. Law enforcement is coming to your house to get this child. Now, you, me, your husband, Ms. Preston, we've all been 11-year-old children in the past, and we all know how that would feel. It would not feel good. So I'm trying to impress upon you the importance of this. Maybe just trying to find some space of agreement with father for the month of July, because that's what the court order that you are under that says. So that's where we are right now.
So can I ask Your Honor one other question in regards to this? If you do sign the order, that would mean that the authorities will immediately come to pick up my child?
Pretty quickly they will.
Okay.
I mean, I would, that's the issue. Now, what Ms. Preston has suggested is that I sign it and give 24 hours for you and husband to work it out. I was really hoping that maybe I wouldn't have to sign it at all. Maybe you would just agree in open court to bring to get the daughter to your husband's house today.
I understand. Okay. So based on the fact that I don't have a representative and I am basically forced to make a decision in this court, I just wanted to say something before I give you my final answer, Your Honor, if that is okay. I am not willingly and in good conscience handing my daughter to my ex, knowing that there are many risks to her and her health and well-being. But because, Your Honor, this is the order of the court, and I have no other I don't really have another option, as you are telling me, is that either way, I'm damned if I do, I'm damned if I don't. So I am forced to take your advice, Your Honor.
This is not an advice. This is a court order. I mean, and I'm not clear. The only thing I'm trying to do is enforce a court order, and that's why I started asking about CPS.
My apologies.
Okay.
My apologies. I chose the wrong word. And that I will have to accept the court order because I have no other choice. But I just wanted the court to hear my voice and hear my child's voice that I am doing this reluctantly, but I am following the court's order because it is a court order and I have no other choice.
Okay. All right. So let's do this. Ms. Preston, I think what I am going to do is what time is it now? It's 2:40. It's 2:40 and it's Thursday. When do you think you can get your daughter over to your ex's house? How do you all want to handle that?
If it is okay, Your Honor, my child is currently at a summer camp, and I can go pick her up around 3:30 if it's okay, because I also need to help my brother with his medications. And if, I don't know, 5 p.m. would be okay.
5 p.m. would be just fine. Please get her to your ex's house by 5 p.m. and make sure that she has, her clothes, any medications with her toiletries that she needs, her toothbrush and things of that nature. And if she has a summer schedule that he's going to be following, if she's in the middle of an art camp or something like that, make sure that he has all the information that he needs so that she can continue in her summer activity.
Right.
Okay?
Yeah. The only thing that she has brought with her is her clothes and her phone bag that I will be returning to. Apparently she does have her toiletries and everything at her dad's already.
Good. All right. Well, I definitely, if she typically carries a phone, I want her to keep that phone.
Yes, that should, but that is her dad's.
That is a court order. If this child has a phone, Dad, I want her to keep that phone. Mom, if she has a phone, I want her to keep that phone.
Oh, so
it's the child's power. Okay.
Okay.
So I don't want any messing around with the child's telephone.
Okay, I'm confused now.
Okay.
Because that's what I said. I mean, she has, this phone was
Mom,
purchased by the.
Mom, listen to me. We can't see you anymore, but that wasn't for you. That was for Dad. That was for both of you all. I want the child to have her telephone, because if there is some problem that comes up, we're not here in evidentiary hearing. I'm a big believer in kids having their telephones. Okay. And I am suspicious when they don't. So that was not for you, Mom. That was for Dad. I just want the kid to have her telephone. Okay.
Yes.
All right.
That
So we got that. Now let's move on. Let's move on.
Sure.
All right. So you're going to get her over to Dad's house at 5 o'clock today. Is that right?
Yes. Yes,
Okay.
correct.
All right. I'm not going to sign the writ of attachment right now. Might not sign it at all. But Ms. Preston, if tomorrow comes and tomorrow comes and the child has not shown up at Dad's house by, 5 this afternoon. We all know Austin traffic, 5:10, whatever. But tomorrow morning, and the child's not there, then I will sign the writ of attachment, and that will get law enforcement involved. But I think that right now we don't need to do that. Okay.
Yes, ma'am.
All right, Ms. Preston, now, are you still wanting to talk about the show cause and the other thing, or do you want to just go forward with this and let everyone enjoy their July and try to do something on the other later? What's your plan?
I'd like to just get the hearing set. Of course, if mom obtains an attorney and the attorney's not available or anything like that, obviously I'm willing to work with her. I'm also willing to set the hearing out longer than July, especially since my client will have possession now for the month of July.
Yeah.
But if the court is willing to give us a date and order us to appear, I would appreciate that.
Well, I would have to call Mr. Stokes to get that date for you all. Why don't you all do that and find a date? Mom, and I'm sorry I keep calling you that. I don't have names on this one right now. And I can see is very limited here. What she's saying, Mom, is she's saying that since Dad did not get to have your daughter over Father's Day, they're hoping to have a hearing on why he shouldn't have some additional time with her in the future. Did I state that correctly, Ms. Preston?
Yes, ma'am.
All right. So it might be possible, Mom, rather than to have a hearing on that, maybe you all could work something out, like he gets an extra, I don't know how much time she missed over Father's Day weekend, but maybe a little extra time at the beginning of August. That might avoid having to have another hearing on this, and you having to get an attorney to go there. So that would be another option. Do you hear what I'm saying?
Yes, Your
Okay.
Honor.
So why don't you all think about that? Ms. Preston, how much more time are you hoping to have?
We would just be asking for makeup time for the time that's been missed. So that would be or something 3 days over Father's Day weekend, and then the last 7 days that were missed.
Of July?
Yes, ma'am.
Okay. So let me ask Mom. I mean, I guess one option is we can have another hearing on this. So Mom, what she's saying is that there were 3 days. Can you hear me?
Yes, I'm sorry.
She was saying that there were 3 days over Father's Day, and then there were 7 days the first week of July that Dad has missed with your child, with the child that you all both are the parents of. And so what Ms. Preston is saying was, gee, Your Honor, I'd like to have a hearing so I could try to get that time back to my client. And I'm just saying, maybe rather than have a hearing, would you agree to let the child stay on another 10 days into August so that you all don't have to have a hearing on that, and he makes up the time that he missed with her?
Your Honor, it's very difficult for me to say anything without representative. Is it possible that I have a representative and they communicate with my ex's lawyer?
Yeah.
In regards to this?
Yeah, that's fine. I was just trying to save you all a little time and money, but yeah, that's fine. So what we're going to do, please get your attorney. Do you have an attorney or do you not have an attorney?
At this moment, I don't.
Okay. Well, if you're going to, so you're putting some hoops out there to jump through. Keep in mind, you got to get an attorney and we're going to set a hearing. So go on and get you an attorney and then we can talk about this. The other easier option would be, I think, just to go on and let Dad keep the daughter that you all are both are parents of for 10 additional days in August. Another option. Okay. So Ms. Preston, why don't you go on and draft an order and let's circulate it, send it to Mom to look at in that regard, in terms of that being an option. Mom, I will not be issuing any writ of attachment for this child as long as you get her over to Dad's house by 5 o'clock this afternoon. Okay.
Yes, thank you, Your Honor.
Yeah. So we're all squared away for the rest of July. Mom, you might think about, Ms. Preston's suggestion that we just tag 10 days on to the end of this, and you don't have to have any more legal action around the 3 days that were missed over Father's Day weekend and the first week of July. Okay.
Yes, Your Honor.
All right. So Ms. Preston, you put that together and circulate that.
Okay. So just when you thought I was going to play Judge Bryant, I'm not. Curveball. Thank you, Sarah, for this clip. We are definitely missing. Judge DeSanto. She's on vacation, I think. Her court's closed for a week or two. I know Rebecca told us about that. I haven't seen Rebecca Lynn today. So, I have an oldie but goodie. I was going to play Mr. Mead, but that's a little too long. So, I got this guy. This guy's great. Let's have some fun with this one. Thank you, Sarah, for our Dono clip of the night.
Council, on March 25th, Mr. Hill was arrested on charge of domestic violence and assaulting, resisting an officer. He was then brought over to circuit court because he waived his exam. Then he had contacted probation in April, indicating he'd been placed on a tether through the Wayne County Jail. And because of his incarceration, was unable to start anger management. On April 18th, he started with Detroit Recovery Project. And apparently, as of June 23rd, is now enrolled in a 13-week anger management course.
That's correct, Judge. Mr. Hill has been doing his anger management. I believe he has his 4th class this week. The domestic violence charge was ultimately dropped, and Mr. Hill did plead guilty to an attempt resisting and obstructing a police officer. He has been going to the Detroit Recovery for counseling, but his last appointment there, his counselor was not present, and nobody ever called to let him know that they had essentially canceled his counseling visit that day. So moving forward, Mr. Hill wants to go to a place that he wants to find a new place that's a little bit more professional and will at least let him know that there could be potential changes. Additionally, Your Honor, he does plan on start making payments towards his costs and fines next month. So at this time, I would simply just be asking that his jail review be set out once more. Thank you.
All right, thank you. And so, Mr. Hill, I see that we have proof of that you had an intake scheduled in April, but we don't have any updated information regarding your counseling. Have you been attending your counseling appointments other than the last one that was canceled?
Yeah, Your Honor, before that, I got scheduled when I did my intake. I got scheduled, and when I went in, they didn't even have me like on the appointment sheet. So it kind of like threw me off, and then I set another appointment because the way that the therapist is, I'm working 6 days now, Your Honor. I've been working for like the past 5 weeks. So I work 12 hours a day. I'm working from 6 to 6. So I tried to set aside and get time off of work to go to therapy. But then when I just went in, when they scheduled me another appointment, because her late days is only on Wednesdays. So my manager let me, leave early. I told her I was going to therapy, so she allowed me to leave early. And when I got in there, the lady said my therapist just left. So I was telling my lawyer, like, if somebody could give me any leads to some place that's more professional, because I just don't like the whole scenery, and it seemed like they need more help than me, Your Honor.
They need more help than you? Okay.
Yeah, Your Honor, it's bad.
Look at the girl in the top right square. She's like, oh, no, you didn't. No, you didn't, you dope.
They unprofessional.
What?
And I don't want to have to keep missing work. I just got there. So I don't want to keep calling off. And they didn't. And the thing about it, I called them earlier that day, Your Honor, and asked them because it happened to me before, and asked the lady, was everything solidified for 5 o'clock on Wednesday? And she told me everything, I was on the schedule and everything was solidified to come in. And when I got in there, she said, my therapist left 30 minutes ago.
Okay. So, sir, you're going to have to contact DWIN again, Detroit Wind Integrated Health Network, to request a different location. So you're going to have to do that today since you're off work, right?
Yeah, I'm off. Okay, yeah, I'm off, Your Honor. Yes.
So make sure you're doing that today.
Okay. And I when I got enrolled in anger management, I took I'm gonna take 2 classes every Saturday, so I should be done with that within 4-5 weeks. Because the guy that's running the class said he allowed me to take 2 classes every Saturday, so I'll be on my 4th class Saturday.
Okay, well, sir, and that's fantastic. However, what I want you to do is I want you to not rush. I want you to not rush through it. I want you to take time to receive what you're being given. Okay, and I want you just to rush through it, just to check it off to say you're done. I want you to be present in the moment, so you're taking in what you're getting.
Thank you, Sheriff.
Okay?
Yes, Your Honor.
Another member.
Okay.
Welcome, Irving.
Okay, so we can set this matter. We'll adjourn this to August 21st at 10 a.m.
Oh, we'll be there for that one. Guys, I hope you enjoyed that. We need a little DeSanto in our lives every day. Guys, I will see you tomorrow. Happy pre-Friday. Hopefully, Simpson will call me out tomorrow. I will be recording. I will be live. I'm Phil. This is Tom. Thank you again. You're always being served.